Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, it's December of 2022, which means we are waiting any day now for ATF's new rule on pistol braces to drop so we can all figure out just exactly how screwed are we for real. Now, if the rule turns out to be anything like the first published version of it, yeah, this is going to be a gigantic mess. If it goes the same way as ATF's rules on frames and receivers did, the final version of the rule was much more tolerable. I didn't say good, but I said more tolerable than the first version. But, you know, as we all gear up for this huge war that we know we have coming, because the battlefront for the Second Amendment is going to be fought predominantly over pistol braces in the year 2023, I think we are beginning to lose sight of a very, very important case that no one seems to talk about enough. So today, we're going to spend a few minutes and get you all up to speed on the one case that will definitely kill ATF's gross overreach on pistol braces. Okay, so the issue we're talking about for the 173rd time now is ATF's new rule on firearms with attached stabilizing braces, of which we have done way too many videos, and we are even trying to predict when this rule is going to come down. Now, once the rule comes down, we all know the drill. We got 120 days to figure out what it all means before it becomes final, and most definitely, during that 120-day period, the lawsuits will start flying from every corner of the country. Now, a lot of you have already been armchair quarterbacking this thing, telling me all the arguments that need to be made when this rule drops and how to challenge it. And almost every single one of those arguments has focused on the Second Amendment and predominantly a very recent case called New York Pistol and Rifle Association v. Bruen. Is it my job today to get you all up to speed on that? No, because that is not the case I am talking about. No, I want to talk about the case that really, truly has the chance to stick it to the ATF when it comes to this gross overregulation of items that they previously ruled were legal. And the case, of course, that I'm talking about is West Virginia versus EPA. Now, we've already done a video on this, and it didn't get as much traction, but I want you to really understand the importance of West Virginia versus EPA. See, this was a case that was decided literally around the exact same time as the Bruen opinion. And while the Bruen opinion got a ton of publicity, and for good reason, because it is a brilliantly written opinion, it absolutely significantly changes the landscape of Second Amendment litigation moving forward. But the import of West Virginia versus EPA to the ATF directly and to any alphabet agency that matter, that's the most significant component that we need to talk about. Okay, so what is this case all about? West Virginia versus EPA. Well, in a nutshell, what happened is that when the Biden administration came into the White House, they immediately adopted all new energy policies. And shockingly, all of those energy policies were designed to absolutely screw the fossil fuel industry and, of course, promote green energy. Now, I don't care to get into a green energy debate or anything like that on Washington gun law, but rather than go out and pass significant forms of legislation which may have altered the American energy industry to a way where we would have shifted away from fossil fuels to more green energy. No. What the Biden administration tried to do was, you know what? We're just going to force this upon the energy industry through EPA regulation and rulemaking. Oh my God, does that sound familiar? That's right. Think about this for a second, okay? Here's the Biden administration that flat out says we don't have the clout. We don't have the votes to go to Congress and to pass significant overhauling of America's energy policy through legislation. And because we can't do that, but we still have this agenda, what we're going to do is we're going to turn the EPA loose like some sick little rabid attack dog that you just let off the leash to go sick themselves upon the energy industry. What the Biden administration essentially did through rulemaking, again, does this sound familiar, is that they created all sorts of new rules that essentially killed the fossil fuel industry, predominantly killing coal. Now, you can imagine when you start killing the coal industry that the good folks in West Virginia are none bit too happy about that, because that could have a significant economic impact on the entire state. So West Virginia sued the EPA saying, hey, listen, you guys are violating the separation of powers here. And you sit there and you go, whoa, wait a second. How are they violating the separation of powers when the EPA just implements these new green initiatives? Well, here's what happens. You see, if you implement all sorts of new energy rules and policies that essentially shuts down one segment of the American energy industry and transfers all of that wealth into brand new green energy industry, that is such a significant shift in commerce in the United States that that's considered to be a major question. There is a long-standing doctrine called the Major Question Doctrine that basically says that if there is a major question that's going on, that is not to be left to an executive agency. Rather, that needs to be done through an act of Congress. So when the Supreme Court shot the EPA down, what the ruling basically was is, EPA, you came up with all of these new rules that essentially kills the coal industry and puts all of this new revenue into green energy, and there hasn't been one single new law passed. There hasn't been any act of Congress whatsoever. There are billions and billions of dollars that are now transferring from one industry to another without any legislation attached thereto. That is being done by an executive agency rather than by an act of legislation, and for that reason, we have a violation of separation of powers. You see, when we have a major question, such as shutting down one segment of the American energy industry and propping up another segment of it, shifting billions of dollars, that's a major question. And if it's a major question, the major question must be answered by Congress, not by an executive agency. Okay, and here's the big thing about the West Virginia versus EPA case, is that the holdings are not unique or exclusive to the EPA. You see, this applies to any executive administrative agency, or what we call the alphabet agencies. So yes, the FCC, the SEC, the DOT, any of those agencies with 3 or 4 letters, including the ATF. You see, because what the ATF is going to be doing with this pistol brace rule is taking millions and millions of firearms, which they previously, through their own rulemaking, and said, hey, these are totally okay. And in the instant that the rule becomes effective, just like that, millions and millions of firearms are going to go from lawful firearms to now federally regulated NFA items, all requiring taxation of $200 per firearm. Now, the estimates are somewhere that firearms equipped with pistol braces are somewhere in the 10 to 40 million range. I candidly think at the conservative end, it's probably on the high end of that and probably beyond that. Now, you take the number of firearms that are currently lawfully, legally owned in the United States and tax each one of them by $200 and subject that individual now to a whole new slew of federal regulation and oversight, which they never signed up for to begin with, and to be all done through rulemaking and not a single act of Congress, well, that, my friends, is a violation of the separation of powers, and it's in direct violation of the very clear holdings of West Virginia versus EPA. And so the point that I want to make is that when this pistol brace rule drops and it's time to roll up the sleeves and start the battle that will be the war over pistol braces, the most effective piece of ammunition we have may not be the Second Amendment, and it may not even be New York Pistol and Rifle Association v. Bruen. It, in all likelihood, is going to be the holdings of West Virginia versus EPA. Listen, in the meantime, if you have any questions about the pistol brace rule or anything else that might be related to your Second Amendment rights, you know the drill. You can always contact us at WashingtonGunLaw.com, or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.